see this come up on your screen. So if I can move that out, so there it is. Yeah. So set out or attach the grounds. So I've attached the grounds and set out some grounds in this application. So Guy and Harry Moore is the subject of the realm of England, 13th of September 2019. Dear Sir, Madam, RV Cherry and others, case reference UK SC 2019-0993. Application for permission to intervene. 1. Graham Moore seeks the permission of the court to intervene in the above proceedings, which are listed to be heard by the Supreme Court on the 17th of September 2017. The nature of the interest of Graham Moore in the proceedings and the scope of the proposed intervention are set out below. 2. Graham Moore seeks permission to intervene by way of written submissions listed below. Plainly, Graham Moore would not seek any order as to costs, and it is not anticipated that any order for costs would be sought against it. Accordingly, the intervention should have minimal effect upon the length of the proceedings and no effect upon the orders made for costs. Graham Moore is a subject to the realm of England and as such has standing. The subject seeks to intervene to assist the court for 3 reasons. 1. England is not represented by its own court or a minister for England. 2. Whilst the Scottish court has recognised the Claim of Right 1689, either party has not referenced the Declaration of Rights 1688, a contract, the Bill of Rights 1688, a statute, the Crown and Parliament Act 1688, the Coronation Oath Act 1688, and or the Acts of Union 1706-1707. The latter clearly states that England and Scotland's rights prior to this act still exist. And number 3, the English Constitution is now being ignored. So they are acknowledging what they refer to as the Scottish Constitution and ignore completely the English Constitution. And please remember, everyone, that the Claim of Right was extended to Scotland from the Bill of Rights. So please see the submission continued with appendix. I'm currently unemployed and seek the court's waiver of the fees and costs. This is a simple, short written submission only. 13th of September. So this is the full submission. It's a written submission. That means they won't call me to give oral evidence, although they could if they wanted to. But what the important of if you want to intervene as a friend of the court, which is what I'm doing, yeah, there is a specific process. The shorter you keep it, the more succinct it is, and it can assist everyone in the court, the judges, the respondent, the appellant, etc. Right, all sides. Because this is about the Constitution. I'm not taking sides with anyone. I'm just saying this is the law. Right. So 13th of September, address applied to court. Dear Sir, Madam, RV, and then you've already heard the first part of this. Yeah. So what I'm going to do is say this. Graham Moore is an English constitutionalist and believes in right and wrong, the rule of law, not left or right politics. The Bill of Rights 1688 clearly states, right, and then it says laws and liberties of this kingdom, so that the same for the future might not be in danger again of being subverted. That's really important. Remember the word subversion, right, because I'm going to come back to it in a couple of minutes, well, at the end of this. Then it goes into the whole paragraph is important, but I have highlighted and sectioned off some of the parts, right? So it says, therein contained by the force of law, rights and liberties asserted and claimed in the said declaration. Bearing in mind they're talking about the Declaration of Rights, which is a contract, right? And I'm going to get back to that in a couple of minutes. As I've already stated above, yeah? Rights and liberties asserted, and then it says esteemed, allowed and adjudged. So it's very important that people realise everywhere that the courts are allowed to adjudge or judge or make decisions on the Constitution, and it clearly states it in the Bill of Rights, adjudged, deemed and taken to be and that all and every particulars aforesaid shall be firmly, and this is crucial again, strictly holden and observed. Right? This is very strong legal terms, as they are expressed in the said declaration, the contract, right? And all officers and ministers whatsoever shall serve their majesties and their successors according to the same in all times to come. Right? So, point 6, the Bill of Rights clearly states adjudged. The Bill of Rights 1688 clearly states for all time to come. The Bill of Rights clearly states forever, 3 times. The Bill of Rights 1688 clearly states shall stand, remain and be the law of this realm forever. Supremacy. The Bill of Rights 1688 clearly states, and I do declare, that no foreign prince, person, prelate, state or pontificate hath or ought to have any jurisdiction, power, superiority, preeminence, or authority ecclesiastical or spiritual within the realm, so help me God. Her Majesty the Queen swore the coronation oath 1688 at her coronation, confirming the same rights do stand. Her Majesty restated by declaration to the Houses of Parliament on July 20th, 1988, that the Bill of Rights of 1688 is in force and part of our Constitution. Hansard. 16. The Speaker of the House of Commons 1993, Betty Boothroyd, expressly advised the courts that the Bill of Rights 1688 was in full force. Hansard. 17. Cato Conspiracy 1820, subverting the Constitution, where 5 men were hung for subverting the Constitution, where five men were beheaded and were sentenced to be hung, drawn and quartered, although that sentence was then committed to hanging and beheading rather than drawing and quartering. A number of others were sent for deportation, not just to Australia, but also to the depths of Africa, where they all met their demise through disease, namely malaria and other actions, and obviously got worked to death in the process. 18. Blackstone Commentaries, Book 1, Chapter 6 of the King's Duties. And then he says, and I'm going to reference the last part, judged proper to declare these duties expressly and to reduce that contract to a plain certainty, so that whatever doubts might be formally raised by weak and scrupulous minds about the existence of such an original contract, again up there, the Constitution is the solution, they must now entirely cease, especially with regard to every prince who has reigned since the year 1688. Then there are Dicey's comments on Parliament, right? 20. This is the first time since joining the EEC, otherwise known as the Common Market, that the public have been asked for their vote with reference to any further treaties or laws. That includes treaties that substantially affect our rights as individuals. When we had an opportunity to vote, we voted to leave. The current situation not only offends against the Constitution, but against the law of natural justice. 1992-93 Maastricht Treaty, no referendum. 1997 Amsterdam Treaty, no referendum. 2001 Nice Treaty, no referendum. 2007 Lisbon Treaty, no referendum. 23rd of June 2016, I voted to leave with a preference to the English Constitution and allegiance to the English Constitution. That vote is being disregarded contrary to natural justice. 21. Graham Moore therefore claims his right of liberty and freedom as our ancestors and God intended. that concludes my submission, my lords.